Hello, everyone. Good afternoon. I'm Charlie Weng, Associate Professor and a member of UNSW Law's Herbert Smith Freehills CIBEL Center, and I'm delighted to welcome you to the fourth session of the 2021 CIBEL Global Network Conference webinar series. The topic of this webinar is a corporate law and a practice in turbulent times. I would like to begin by acknowledging the Badigal people who are the traditional custodian of the land where UNSW Law stands. I would also like to pay my respect to the elder, both the past, present, and emerging, and extend that respect to other Aboriginal and Torres Strait Islanders who are present here today. As you may know, distrust, geopolitics, and populism are chipping away the achievement of globalization in the past decades. We are facing the challenge of pandemic and a more fragmented world. Disputes in both politics and economy between nations are more often seen than before. The turbulent times challenge corporate law and practice. While recognizing the law is making concessions to politics and the national economy interest more than it should be, we are expecting the law can shape the world and leads us to a better future. I'm glad to announce that we have three great legal scholars on the panel. They are bringing us three fantastic topics on corporate law. The first speaker is Associate Professor Wei Zhang. Professor Zhang is an Associate Professor of Singapore Management University School of Law. He earned his LLB from Fudan University, Master of Art in Civil Law from Waseda University in Japan, LLM from Harvard Law School, and a PhD in Jurisprudence and Social Policy from UC Berkeley. Dr. Zhang specialized in corporate and commercial law and economics, property law, and Chinese law. He focuses on quantitative empirical studies of law and the effects of the legal system on our society. His works have been published in various peer-reviewed journals in US, UK, mainland of China, and Taiwan. He presents routinely at major international conferences in law and economics and empirical legal studies. Dr. Zhang has also been invited as a visiting professor or a guest speaker to top universities and regulatory agencies in China, including Peking University, Tsinghua University, Fudan University, as well as the Shanghai and the Shenzhen Stock Exchange and the Shanghai Financial Court. His talk today is Gatekeepers or Scapegoats, Liabilities of Professionals in Securities Fraud Litigations in China. The second speaker is Associate Professor Lauren Yushing Ling. Lauren is an Associate Professor at City University of Hong Kong School of Law. Her research focuses on corporate law and governance. She relies on empirical data and economic theories to dissect and understand the effect of different governance and regulatory measures on corporations. She has published articles on major topics in corporate governance, such as shareholder activism, securities, class action, board independence, dual class share structure, and governance issues in state-owned enterprises. She regularly speaks at the international academic conferences and has been invited to serve as a referee for top law and finance journals. She has published with leading academic journals such as the Journal of Legal Studies and the Journal of Empirical Legal Studies, and has also been invited by major media, including The Economists and Bloomberg. As a corporate law expert, her topic is China's corporate social credit system and the dawn of surveillance state capitalism. The third speaker is Dr. Xiaochen Zhang. Xiaochen did her SJD at Penn Law from 2017 to 2019, and her research interest is comparative corporate law. She obtained her LLB from CUPL, China University of Political Science and Law in 2004, and her LLM from Penn Law, University of Pennsylvania School of Law in 2005. From 2006 to 2010, she was a PhD candidate in the LLCE. She researched assets-backed securitization as a paid intern in the Asian Development Bank in Manila, Philippines, in 2009. From 2016 to 2007, she was a visiting researcher at Penn Law. She is also doing a PhD at China University of Political Science and Law now, and she and her PhD research is about the regulatory cost of Chinese listed companies. Her topic today is the impact of regulation, the U.S.-China relationship, and cross listings in the after COVID world, which is, I think it's a very interesting topic. So without further ado, let's welcome our first speaker, Professor Zhang. Wei, please.
Thank you. Thank you very much, Xiao-chuan, for your very kind introduction. And I'm really pleased to attend today's webinar. So maybe I can share my slides with you. So this is a quite hot topic, I think, currently in China. It's about the security fraud litigations. We know, of course, the anti-fraud is always at the center of any country's security regulation agenda. For instance, most notably, the U.S. Securities Act. It has a section mainly to deal with the frauds in registration statements. So under which there's going to be strict liability, but with reasonable reliance or due diligence defenses for those non-issue defendants. And once the defendant is found to be liable under this particular rule, it's going to be a joint and several liability. Whereas on the other hand, to deal with those post-issuance disclosure misrepresentations, the U.S. has another rule under the Securities Exchange Act, the famous 10B. But there you need scienter, and actually under that rule, the liability is proportionated. Similarly, in China, we have a Article 85 in the PRC securities law, which laid down the strict liability, but with so-called lack of fraud defense, basically for all defendants. And actually, China doesn't differentiate as the US does from the registration statement fraud and the post-issuance fraud, right? So in both situations, it is a sort of joint and several liability as it is stipulated in the statute. So next slide, please. Okay, thank you. So mainly there are two types of defendants in this securities fraud litigations. One is, of course, it's mainly the issuers, and the issuers are insiders. But here today, we're going to talk about the second type of defendants, mainly those professionals who supported the listing or the reporting process, right? So in this regard, Professor Zhang of Columbia Law School, he had a very famous, actually initially I think a paper, but later on published as a book in 2006, talking about those professionals. He called them gatekeepers, mainly, as you can see on the slides, referring to like accountants, lawyers, and bankers, including credit rating agencies. So he thinks these are the people who keep the gate for the public investors in prevention of the securities fraud. And very interestingly, in recent years, China actually fervently embraced this idea of gatekeeper liabilities under the so-called zero tolerance policy. Of course, the zero tolerance refers to zero tolerance about securities fraud. And as I just said, the PRC securities law has a particular article, Article 85, which says the sponsors, the underwriters, was going to have strict liability and will be liable jointly and severally with the issuers and the issuers' insiders in case of misrepresentation in disclosure. And on top of that, there's another article in the Chinese securities law, Article 163, which expands the same liability to various professionals, like accountants, lawyers, credit rating agencies, actually even more. So, but these are the general rules. Let's just take a closer look at what actually are those liabilities under the US and Chinese law respectively. Let's look at US first. So under the US law, the investment banks, who usually serve as underwriters, indeed, their liability in case of securities fraud are quite high. And essentially the courts want the underwriters to sort of at the opposite side of the issuers and to pit against the issuers, right? To scrutinize the disclosures made by the issuers. So, so to speak, the investment bankers, the underwriters, are playing a central role in the IPO or other, issuance process, because I think also because of the market's reality that the underwriting market is pretty much concentrated in the US, which gives those underwriters, the major investment banks, a lot of leverage over the issuers, that they can play such a role as a gatekeeper. Whereas when it comes to the accountants or auditors, they are actually liable, but just occasionally. If you look at the data, I mean, these are the data, publicly available on the Stanford's securities class action data set. You can see actually in those settled securities class actions, accountants are very infrequently listed as defendants, right? Then we look at lawyers. In lawyers, it is in US, I think almost never liable for securities fraud, especially in the registration statement fraud cases under Section 11 of the 1933 Act. So some scholars even argue that lawyers, they are not good gatekeepers after all, because unlike underwriters, they actually do not gain a lot by playing the role as a gatekeeper to protect investors. And quite on the contrary, their main role is to be a transaction cost engineer, therefore to facilitate the issuance process for the issuers. And then we have the credit rating agencies, which in US is likely to be protected by the First Amendment. And at least I can say the credit rating agencies will not be less protected than other professionals when it comes to the securities fraud litigations. Then we have this, I think it's quite different situation in China. This is a very, I think, very well-known case, and it's actually ongoing. It's called the Wuyang Zai in Chinese, the Wuyang bonds. Wuyang is a construction company, so it issued public bonds, and there were some, frauds, misrepresentation allegations. So the alleged misrepresentations, basically there are two allegations. One is the typical cook the books. In particular, it is alleged that they improperly set off the account receivables and account payables, therefore to somehow manipulate the economics, therefore they will be qualified to issue bonds to the public. And the second misrepresentation allegation is about certain real estate contracts entered between the issuer, the Wuyang Construction Company, and some other third parties. The main issue with those kind of real estate transaction contracts is that the contracting price actually are sort of underpriced. The interesting thing is, before I move on to the next, point, this real estate sales contract, actually these contracts, including the contracting prices, are reported, not concealed, or not fraudulently, stated in the issuance documents. So it makes people sort of kind of wonder why this is a misrepresentation in the first place. Nevertheless, the trial decision, this is, I think, a decision from the Hangzhou Intermediate Court. So the trial decision says the underwriters and accountants, they are jointly and several liable for the entire damages as a result of so-called misrepresentations. And that amounts a total to about 500 million yuan. Whereas the credit rating agency is be liable for 10% of the damages, and finally lawyers will be liable for 5% of the damages. Next slide, please. And then let's have a closer look at the reasoning behind these trial decisions. For the underwriters, the court said that you failed to investigate into those potential accounting problems, although your own staff internally found it is kind of at least questionable whether this particular type of accounting practice is valid or not. But you didn't move on to raise the question. And also you failed to investigate into those kind of real estate transactions. In particular, you didn't pay attention to the actual value of these real estate. And then when it comes to the accountants, the court said, arguably, this type of setup practice is not proper. And then for the credit rating agencies, the court said, you failed to investigate the real estate underpricing, although you're aware of the issue. And actually, as I said, it is the credit rating agency who actually disclosed this. Right? There is certain kind of real estate transactions with certain price, and the real value probably is higher. When it comes to lawyers, the court says there are basically three problems with the lawyers. Right? The lawyers failed to verify the material contracts and material change of assets involved in these contracts. I think this, of course, refers to those real estate transactions. And second, the court said the lawyers failed to exercise the due diligence in verifying property titles. Finally, the court said the lawyers failed to recognize the legal risk concerning the Wuyang's ability to repay the debts associated with the reduction of those material assets. Again, here referring to those real estate. Next slide, please. Let's just have some assessment of the trial decision. I think when it comes to the underwriter's liability, the court decision seems to be proper, essentially disregarded certain kind of red flags, which is, of course, a reflection of lack of due diligence. When it comes to accountants, the court decision may be proper, but we need some further experts' opinions to establish whether this particular type of accounting practice is valid or not. When it comes to credit rating agency, I think that the decision is unlikely to be proper, because remember it is the credit agent agency that discovered and disclosed these real estate transactions. Unless the courts would say that the credit rating agency is an expert at valuation of real estate. Otherwise, I think it may not be a right decision after all. And finally, let's look at the lawyers. Personally, again, I think the decision, that part of decision is not proper. First, the court said you fail to verify the material contracts. This is actually not relevant to the case because, as I said, those real estate transaction contracts are not only disclosed, but nobody says there is any misrepresentation or material omission. And second, when it comes to verify the property titles, again, I think it's never mentioned by the plaintiffs. And nobody complains about, oh, there are some defects in the title of the property. Finally, the court said the lawyers failed to recognize the legal risk concerning the debtor's ability to repay the debt. I find this is very hard to swallow because if you're concerned about, the court is concerned about the debtor's ability to repay debt, should it be a business rather than the legal risk after all? Why the lawyers should be experts to assess those kind of business risks? And next slide, please. And then let's look at another case which was decided after this Wu Yang bond case. This case, the ST Zhong'an case, was decided in the first instance by the Shanghai Financial Court. And the trial decision basically says the underwriter and accountants are liable 100% jointly and severally. Then it went to the appellate court, which is the Shanghai High Court. And the Shanghai High Court changed the trial decision by saying now the underwriter should be liable only for like 25% of the damages, whereas accountants are only 15% liable. So this actually is the first case in China where the court says joint and several liability under securities law Article 85 actually includes proportionate liability, not 100% joint and several. And it seems to be that most Chinese scholars also agree with this proportionate joint and several liabilities. And as I said, the Wu Yang bond case itself is on appeal now, and I think it's likely to be impacted by this ST Zhongzhou case. But the question is whether the real issue is the court should apportioning the liability, which I don't think so. Because if you look at the US courts, they never apportion liabilities at least under the Section 11 cases. Why not? This is because the apportionment is not something needed if the focus is to deter misrepresentation. Of course, I don't have the time, but if you consider the court can make mistakes, lack of apportion may over-deter. But the general lessons from the law and economics is what really matters is not not how much to pay if somebody is found to be below the required standard of precaution. What really matters is whether there is somebody failed to exercise sufficient level of precaution. So in this sense, the real issue in China is to digging into the facts of the cases and try to pin down the levels of precautions of various professionals. Therefore, you can decide whether there is a substandard issue or not. So then finally, I want to just provide a few words to explain why in China this kind of court decision seems to be beside the point. I think the main reason is very likely because of the responsibility of courts. First of all, the courts in China seems to be more concerned about compensating the victims instead of deter the wrongdoings. And when it comes to, allocates the amount of damages, the courts seems to be, have a lot of people, but each pay a little, rather than concentrate the damages. For the simple reason, that seems to be, less likely to stir up negative impact on the court decision. In that regard, I previously had a research in a slightly different context, but essentially, pointing to the same issues underlying the court's incentives. And finally, of course, this also indicates sort of the lack of experience in judging the level precautions based on those factual details. So I think that is pretty much what I want to say today. Thank you very much.
Well, thanks very much, Wei. It's indeed a very thought-provoking. Liabilities of professionals is a very, very interesting topic, and also very heatedly discussed during our alumni gathering as well. So given the fact that the Wei is going to leave us a little bit earlier for some errands for his institution, I would like to shortly open this session to the floor, to the audiences. If you have any questions, please publish the question in the Q&A sessions. I will select 1 or 2 questions to ask Wei first. Yeah, I guess you guys must have some questions about his presentation. Any questions? Yeah, if you have a question, please publish that in a Q&A session. If you don't have questions, then I think I perhaps will let Wei go. I think maybe this is time is too short for you guys to digest, but I think that's perfectly fine. Afterwards, if you still have questions, I can forward your questions. I will try to forward your questions to Wei. Okay, so thanks to Wei very much. Thank you.
Thank you.
Yeah, thank you. Then the second presentation is from Lauren, Professor Ling. Professor Ling's topic is China's corporate social credit system and the dawn of the surveillance state capitalism. So Professor Ling, please.
Okay, thank you, Charlie. So first of all, I'm very pleased to be here, and I want to first of all thank Charlie for invitation, and also to thank UNSW CIBEL Center for the organizing this wonderful event. So my topic is on China's corporate social credit system. So many of you may have already heard about, social credit system in mainland China, where everyone will get a score based on your performance in the society. However, less discussion has been made in relation to the social credit system for corporations, which presumably I think will have more impact on the companies operating in mainland China. So as corporate social credit system is still under development, to give you a first peek into the system about how it works and what are the potential impact, I will be presenting to you the first provincial corporate social credit system that's available from Zhejiang province. In addition to that, I want to introduce a new term, surveillance state capitalism, that has been coined by my co-author Curtis Milham and I to describe Chinese state capitalism after the implementation of corporate social credit system. Next slide. So what is social credit system? It's an overall assessment of human and corporate behavior. So as quoted, it's a complex, sweeping, government-wide initiative that reaches into every sector of the economy and touches on issues such as data, corporate regulation, finance, consumer advocacy, and geopolitics. So it covers various subjects, almost everyone in the society, including individuals, enterprises, which is the focus of today's talk, government agencies as well, and social organization. Next. So as we will show later with our data, we think that with the implementation of corporate social credit system, China is moving from state capitalism to surveillance state capitalism. So what do we mean by surveillance state capitalism? There's no doubt that China is a surveillance state with 54% of the surveillance camera available, in the world situated in China. And it's moving towards this data-driven governance for the social governance, the policy over social governance that utilizes AI and big data analysis. So corporate social credit system has become part of China's tech-driven monitoring and surveillance initiative. So the concept of surveillance state capitalism actually combines several concepts. One is, of course, state capitalism, which everyone familiar with. The second is the surveillance state that I just introduced. And the last one would be a term called surveillance capitalism, which is a term coined by a Harvard professor, Xiaochen Zhang. She described this term as to describe how big tech companies such as Google and Facebook, they have been using big data to commodify human behavior for private gains. So we think that by combining this concept, we create this new term, surveillance state capitalism, to describe the future of Chinese capitalism, which where behavior is amassed and analyzed, not for profit, but in service of the party state's objective, which includes market behavior modification and party fealty. So maybe there's also a potential to achieve what we call the high-tech version of central planning. So what exactly is corporate social credit system? Next slide. How does it work? So the core of corporate social credit system is what we call the public credit assessment. So each province they will do, or each city they will do a comprehensive public credit assessment. That include, there are two main features. One is data aggregation. So they will collect data from government records, market information, and whether you have been red listed or blacklisted by relevant government agency. The other feature is what we call the rewards and punishment. So there's ramification of the assessment results. You get rewards by maybe getting government contracts. You get punishment, maybe be denied of market access, or there's a lot of consequences. Next, so the application of corporate social credit files is quite broad. It's possible that the regulators can deny or grant market access based on the results, or the bank can utilize these results for financial risk assessment. And even the industry association or credit rating agency, they can refer to the credit, the scoring results. Next, so about the development of corporate social or social credit system in general. So it's still, as I said, still under development, and each province is in a different stage. So from this graph, you can see that the darker the color is, that means that there are more documents has been published by the local government in relation to social credit system. So as you can see that more economically developed regions, actually they publish a majority of the documents. And our focus today is on Zhejiang, which is most advanced in publishing, in particular, corporate social credit scores. Next. So our study, we collect data. We collect the scores of Asia-listed companies that headquarter in Zhejiang from the Zhejiang government website. So we did it in July 2021. And we have 531 sample firms in total. So the scores ranges from 0 to 1,000, and there's 5 ratings. Okay, so according to the scores that you get, they will rate you differently. Next. So Zhejiang province, they publish public credit evaluation indicators for 5 types of entities, including enterprises. So we're only showing the the indicators for enterprises. So according to the latest 2020 evaluation and the guideline for evaluation, there are 5 main components, for calculating scores. The first one being compliance. So that accounts for 450 points out of 1,000. Okay. The second being finance and taxation, 195 points. Social responsibility, 185 points. And governance and basic information. Next. So this table shows you the details of the indicators. So what I introduced is the first level indicator, and we also have second level and third level indicators. Each were given a weighting, okay? And in total, that comes to 1,000 points. So what does it include in the basic information? That includes, whether the key corporate personnel, involved in serious dishonest act, whether the company is in abnormal operation. So for finance and taxation, they're looking to whether you fail to perform court judgments relating to financing, whether you pay your tax. For governance, they're looking to product quality issues, safety production, if there is any safety events or accidents, or environmental accidents. Next. So for compliance, which accounts for 450 points, that include administrative penalties enforcement, judicial enforcement. If you fail to perform, the court judgment, you got deducted, deduct points. Whether you have been listed as an enterprise with serious dishonest act, and most interesting is the last part, social responsibility. That taking into account 2 parts. One is charity, the other is honest incentive information. So whether the enterprise volunteer, in any of services, for example, helping the poor, support social activities, participate in the rescue activities during pandemic, or if you make donations to the society. And the last one will be, red list or honors and award information. So if you get award from the government, you get more points. So the last part of social responsibility is a little bit different from the other part, because the other parts, they start from full marks and they deduct points. But for social responsibility, they start from 0. And if you do more, then you get more points. Okay, next. So I'm showing you an example of, how the data looks like. So this is the Zhejiang government website, a portal where you can check the public credit information and the scores for every company. So we just randomly, clicking Alibaba, right? And there's many Alibaba companies. This is just one of them. So here you can see that, they shows the Unified Social Credit Identifier, which is an ID that given to every registered company in mainland China. So here you can show that the rating is excellent, and you can see the marks is a little bit less than 900. Next. So on the same web page, you can also see there is a basic information about this company, who are the legal representative and that. Next. And most importantly, they also show you, whether they have like negative information or positive information, being blacklisted or red listed. So here, this company, it has been listed as a A-level taxpayer, so red list. So that add points. Okay. Next. So about our outcomes. First of all, on the ratings. So you can see that 3/4 of the listed firms in Zhejiang actually received the highest rating. Okay, excellent. So that means, almost most of the listed companies in Zhejiang, they're doing very well in the rating. Okay. Next, about the scores, distribution of the scores. This graph shows you the average score of the first level indicators, the 5 components that I just showed you. So from this graph, you can see that, okay, in the main score is lowest for social responsibility. That's 38.25, 25%. So this suggests that, maybe this is the part that the company can work on in the future, because there are a lot of room for improvement. You can make more donations, try to get awards, or try to volunteer, in those recognized activities. And perhaps it's not coincidentally that these are precisely the areas of emphasis in President Xi Jinping's current campaign to reduce income inequality and promote common prosperity by asking wealthy individuals and private corporations to make donations. So that could be, the future trend in corporations' activities to increase points. Next. So we also show you the average score in the second level indicator. So again, charity, honest incentive information here receive the lowest score, especially charity. So, I think we can predict that, in the future, maybe more companies will be doing donations and all that to increase and boost up the scores. Next. So in addition to the distribution of scores and ratings, we're also interested in, what factors would affect or correlated with corporate social credit scores. Now, there are a few variables that we're interested in. Now, first of all, because corporate social credit system is really a system measuring legal compliance. Okay, whether you comply with the rules, whether you comply with law. So we would imagine, for good corporate governance firms, then they should score higher. All right. And another key concept in the corporate social credit system is what we call credit, right? Trustworthiness. So whether you be able to pay your debt, did you satisfy the judgment? So that would have something to do with your financial condition. So, how many debts you have, we use leverage ratio, we use ROA to look at, whether that's related to the scores. Now, the third factors that we think is relevant is the formal link to the party state. Okay, whether you have more state shares or are you at SOE, would that affect your scores? Lastly is, informal link to the party state. So political connection has been shown in the existing literature that, it affects a lot of the outcomes, either legal, social, or political outcomes. So we wanted to see whether political connected firms do well or better than non-connected firms in the scores. Next. So I'm showing you the regression results. So this is the regression. We ran two regressions, one on total scores, the second on the first level indicators. So on total scores, if you can focus on model 5, where we put all the variables in, you will see that, okay, highly leveraged firms, they score lower. That's consistent with our prediction, right? Because they are subject to higher default risk. They are not able to satisfy the judgment. They're not able to pay back the debt, so you deduct a lot of points. The other variable of interest is political connection. So political connection is consistently significant and positive in the regression. That means political connected firms would get higher scores. Okay. Next, we also look into the first level subscores. So we also want to know how do they do in each component. Okay. So from this regression, you can see that the first indicator is for corporate governance, percentage of independent directors. So the more independent directors you have, you get higher score in compliance. That makes sense, right? And leverage, again, is consistent with our first regression that they, highly leveraged firms, they did worse in a lot of the sections. And the formal link to these party states, it seems that it's not very consistent, okay? The result here is not very consistent, but in general, if you have more state shares, you do well in compliance. And interestingly, if you adopt the party building provisions, then actually you didn't do well in finance and taxation. That might be because, those firms that are financially distressed or something, they feel that they need to show fealty to the party. That's why they incorporate, party building reforms. Lastly, the political connection firms. So we know that they did well. They receive higher score, right? So where does those score comes from? Actually, political connected firms, they receive higher score not because they have good higher scores in compliance, they did well in governance. Actually, it's because they get more points in social responsibility. So they collect more soft merits from the party states. So that's an interesting finding. Next. So to summarize, corporate social credit system is facially neutral. It actually measures legal compliance and civic behavior. So as we demonstrate, better governed firms, they score higher in compliance. Highly leveraged firms, they are associated with lower total scores. And formal connection to the state and party, it seems that it does not matter. And finally, political connection matters. If you have political connection, you get higher scores. So we think that political connected firms are best equipped to navigate through the system of rewards and punishment meted out by the party states. And finally, we think that there is a potential for behavioral modification of corporate social credit system because social responsibility rewards those who they will follow what is in the CCP's policy priorities, and there's also a high payoff to effort potential to boost the scores. So there's a potential to modify corporate behavior by putting into policy priorities and concerns into the scoring system. And of course, there's a qualification that our findings have clear limitations because it's only the first rollout of the the scores in Zhejiang, and we only provide an early window into the design characteristic and the potential implication for the whole country. Next, so by conclusion, we want to link back to our concept of surveillance state capitalism. We think that there is a potential for policy channeling through the scoring system, for example, the social responsibility part. And it will nudge the corporate behavior to align with policy goals. And in addition to that, scoring criteria is actually subject to change by local governments. Actually, we've seen different criteria set by different governments, local governments, different provinces or different cities. And a lot of governments, they will prioritize what's important at that time at the national level. So finally, it seems that for central planning, it doesn't work because there's information asymmetry, there's incentive problem, but maybe there's a high-tech version of central planning coming back with assist of technology and the implementation of corporate social credit system. Next, thank you. And I think that's all for me. And look forward to the discussions or questions. Thank you.
Thank you very much, Lauren. I think it's very thought-provoking presentation. I think quite a lot of audiences might have questions. So I just keep the questions with you to the Q&A session. So the next presentation is also the last presentation is from Xiaochuan. Her presentation is the impact of regulation, the US-China relationship, and a cross-listing in the after-COVID world. Xiaochuan, please.
Thank you for giving me this precious opportunity to share with you about the impact of regulation, which is the after-COVID world cross listings in China. So next page, please. A well-accepted theory for cross listings is the bounding hypothesis, which means when the company chooses to list in a foreign jurisdiction, they bound themselves voluntarily to better shareholder protection and higher listing standards, which means it sends signal to the market and to attract more equity capitals. This seems a common story for firms listed in the United States, especially for these Chinese companies entered the US capital market through IPOs. But there is another story for the Chinese firms use reverse merger to enter the US market. They usually have smaller size, and they were criticized by like Harvard Law School professor Jesse Fried as their law proof. So what does it mean by law proof? It means that these companies do not subject to any securities law, including US and China. So from the numbers from the PPT, we can see that these reverse merger Chinese firms are usually much smaller than these IPO Chinese firms. Next page, please. It's really weird. Oh, I can see my PPT now from the screen. Okay, cool. They have different reasons for listing in the United States. For this bonding group using IPOs, normally they are SOE, state-owned enterprises, and they intended to improve their corporate governance and to match the international practice. In the early 90s, they even want to represent in China to the world that we are like international companies, we are modern corporate governance companies. But the other group, the law proof group, is the group that with most problems and the so-called credibility crisis of the China concept stocks. So these groups, they usually do not have access to mainland China capital market at the first place because of the government regulation in Chinese IPOs. Like for example, previous years they require like 3 years of consecutive profit making requirements, which is quite high requirement for these high tech firms. And usually the waiting time is more than a year. And especially the approval from CSRC is unpredictable, and maybe the CSRC will just suspend all the applications for unpredictable time. And so for all these reasons, these Chinese firms choose to use the US market to collect equity capital. Next, please. Okay, so there were two crises of China concept stocks. One happened like 10 years ago, and the other happened after the COVID. After COVID, it begins in the 2020's January, began again with the Muddy Waters reports on Luckin Coffee, which reported that it fabricated its reports and the sales figures. So next, please. Yeah, so for this group of Chinese firms, they have 3 criticisms for it. The first is that mainland China securities law actually cannot apply to them because, strictly speaking, they are not Chinese firms. Most of them incorporated in Cayman Islands. And the regulators and also the violation happens outside China. So Chinese regulators cannot directly punish them through Chinese securities law. Then the second criticism has been pointed out by the SEC and the PCAOB as like the class action remedies for them are limited because the assets are overseas. And the third criticism, which triggers the conflict, the regulatory conflicts between US and China, is the PCAOB issue, which means the SEC or the ODJ, they have limited ability to bring actions in China because they have limited access to the audit working papers. For example, the 2020 Chinese securities law requires that without CSRC approval, they cannot send these materials to foreign regulators. Next, please. So I will explain to you why I will use Luckin Coffee to show you why the domestic Chinese securities law cannot regulate these Chinese concept firms. Like in the end of July 2020, the CSRC issued an announcement which sanctioned the Luckin Coffee for its false statements, but notice that the fines were issued not by the CSRC, it's issued by the State Administration for Market Regulation. And it's under the Anti-Unfair Competition Law, which is not under securities law. And also the CSRC cannot directly punish the wrongdoer, the Luckin Coffee. It can only punish the Luckin Coffee's domestically linked NEEQ listed companies, but not the Luckin Coffee itself. So it shows that the difficulty of Chinese regulators punish the wrongdoers through Chinese securities law. Next, please. The PCAOB issue is that according to the SOX Act, all PCAOB registered firms should allow PCAOB inspections for like complete and timely access, but PCAOB claims that it lack of access in China. And so actually in 2013, China and the US already signed a memorandum of understanding about PCAOB's inspections, but of course, it seems PCAOB is unsatisfied because in its official website in 2021, it clearly states that Chinese cooperation has not been sufficient. Next. Yeah. So the Harvard Law professor called it as a great legal war of China because according to China's state secrets protection law, it's banned sharing of key documents. So the SEC can obtain working papers only after CSRC allows them to do so. Next, please. So the key of US-China regulatory conflicts is that the US concerns is the investor protection. They want more information disclosure, and they want more direct inspection into audit working papers or independent inspections. But China's concerns is that there may be some sensitive information in audit working papers, and if we allow them to do so, then it may affect national security. So China proposes a joint inspection according to the IOSCO, but of course US is unsatisfied and it upgrades its reactions. I will show you how US side upgrades responses later. Next, please. So the first step in the US side is the information disclosure. It requires more information disclosed. So in April 2020, SEC and PCAOB jointly announced that if you invest in Chinese-related firms, you have risks and you have limited remedies. And so, and it clearly states that the PCAOB's inability to inspect audit papers continues. And it requires the issuers to clearly disclose the risk. And it also made discussions with the US audit firms to ask them to ensure the audit quality and keep the quality of member firms globally. So next. And also it provides a list of all the firms that using audit reports where PCAOB cannot have full access to. So it's also another step of information disclosure, disclosing the risks. Next. And so, and then they request like the registered funds and investment advisors is also like make cautious decisions and disclose enough information and things like that. Next. So another step is the president's working group on financial markets. And in this report, they request like Chinese cross-listing companies should meet the US investor protection standards, and they require that the SEC should provide rules to implement these recommendations by the end of this year. So it means like we have a period of transition. Next. And what China's response is that it reduce the requirement, reduce the threshold for listing in China and trying to attract more these so-called red chip companies, these overseas listed firms, to go back to Chinese market. And actually, they have already had 2 firms successfully relisted in the mainland market. Next. And then another upgrading response from the United States is the very famous Holding Foreign Companies Accountable Act. In this act, it proposed a compulsory delisting if you failed to comply the requirements for 3 consecutive years. And so you must allow PCAOB to inspect audit papers. If you cannot do so, then in each inspection year, you must disclose, like if your board members have Communist Party members, then you must disclose their names, and it must disclose that the Chinese government's interest in these companies. So it's very clear that they have some political sense besides investor protection concerns. Next. So another very clear signal of the US side's non-investor protection concerns, which means the political concerns, is by the end of last year, the NYSE requested 3 Chinese telecom firms to be delisted. And their reasons is that they are communist Chinese military companies out of the national security concerns. Of course, this is a political concern. And next. So China's Ministry of Commerce responded by directly points out it's a suppress of Chinese companies and abuse of national security, and they want US to go back to a cooperative way, like to mutually establish a fair, stable, and predictable business environment, things like that. So next. So finally, is the China side response is still sending signals for cooperation. Like in this year, in the opinion issued by the Chinese government, they shows that we will enhance cooperation, cross-border cooperation, and we will enhance the quality of the information disclosure. So these are all signals sending by China that we are looking forward for more cooperation, but not confrontation. So next. So so far I show you the institutional confrontation triggered by cross listings. Well, the problem of China is that for these reverse merger firms, they were triggered to the US market because of the regulation. And so sometimes we can see that more regulation just may create circumvention, but not what the lawmakers expected. And on the other side, it may create unpredictable problems because for these reverse merger firms, because China, for example, they have a very high listing standards, and most firms, they cannot fulfill this like the profit requirements, also they will just choose to make false financial statements, fabricate their numbers. And so when they are used to do that in China, and they did not expect that the US market is playing on the completely different way. So that's why the credibility crisis happened again and again. So, then I want to say that there is a very clear trend after the COVID-19 is the anti-globalization, because the US side shows more political concerns rather than pure investor protection. So, but I think for the long run, both US and China need each other, and we should go for a win-win style rather than like anti-globalization trend. So I hope in the future it will be more cooperation. Thank you, that's all.
Thank you very much, Xiaochen. Interesting presentation. Thank you very much. So now let's enter into the next stage, Q&A. Please feel free to ask questions through Q&A function on the Teams. We will pick the question with the most likes to ask our presenters first. Please take your time. Let me take a look. It seems there are questions being asked already. Oh yeah, there are questions. So okay, since there is a one, by Professor Emma Armson, our very own Professor Emma Armson asked a question to Professor Ling. So thank you, Lauren, for your fascinating and important presentation. I think there are two questions. Are you able to comment further on the consequences for a company in terms of its ratings for the public credit scores? For example, does it impact their ability to obtain funding from banks and or the public? The second is also, can you elaborate on how the information for the scores is gathered and the possibility of companies challenging the final scores? Yeah, thank you.
Okay, thank you, Charlie, and thank you, Emma, for the question. I think this is a great question, which I didn't really have time to cover in my presentation about the consequences of the ratings. So as I showed in one of the graphs that there is the ramification being there is a rewards and punishment system. But you won't get direct like punishment by just scoring very low. Actually, you get direct punishment by blacklisted by any of the government agency. And for listing, for the scores, if you get lower rating, actually there is a national policy, and also Zhejiang also implemented what they call the new way of governance that's called the credit-based hierarchical and categorical supervisory mechanism. So that's called the 分级分类监管. Okay, so depending on which rating you have, right? So in Zhejiang, if you rate it as fair and poor, that's lowest 2 ranks, and or you get that blacklisted, then there is a strengthened supervision from the government agency. For example, they will increase random inspection on your company, and they can order you to rectify your conduct or do some reform, to rectify the conduct. So I think China, by implementing this system, they're moving towards what they call the precise governance, or AI governance, precise governance, or targeted sanction. Okay, so they target the group that didn't do well, and to enhance the inspections and supervision from the government. And that way they enhance the administrative efficiency and also reduce bureaucracy. Because if you do well in the rating, then you might get benefits from, maybe there's less inspection and there's you don't need to file as many documents when you apply for any any application that needs government approval. So the other question from you is, does it impact their ability to obtain funding? I think so. I mentioned that there are different applications. There's wide application of these scores, right? So the bank, they can rely on this rating, but that's the bank's decision, right? In fact, in the past year, during pandemic, many small and medium enterprises, they have financial difficulties, and the bank actually rely on the credit score of each company and to grant loans to the company based on their social credit scores. And if you get blacklisted in one of the agencies, so that's under the concept of joint enforcement. So I think over 45 or some government agencies already signed the joint enforcement memorandum. So if you didn't pay tax and you get blacklisted by the tax department, then it's likely that the CSRC will not grant application for issuing new shares or bonds. Okay, so it's possible that if you get, especially if you get blacklisted, it will impact your ability to apply application in many other departments. So how the information of the scores is gathered. So the scores that I show here is what they call the public credit scores. It's mainly about the government records. So it's a gathering of government records and also from judicial departments. So and they actually each province is in the process of building a computer system where they can gather and update the information from each department, government agency, maybe once in a month, or depending on how they gather the information. But basically, these are government records. Now, the market information has not been factored or taken into account in the public credit assessment, but that's underway. Maybe in the future, it will come in other forms. And it's possible for companies to challenge the final score, yes. So there's another huge area is called rectification, 信用修复. So you can rectify the scores, or if there is errors, you can ask the government to correct it, and you can rectify by doing the goods, or after you rectify, you can apply for rectification and to restore your score. There are many regulations. Actually, each province they have been published rectification rules on how to rectify the scores. That's it. Thank you.
Thank you, Lauren. Very clear. Then let me take a look. What's the second? Okay, let's pick one for Xiaochen. Thanks, Xiaochen, for your presentation. The question is, could you tell me more about the impact of HFCAA? Will most China concept stocks delist from US and go back to the mainland China or Hong Kong stock markets? Please.
Thank you. Actually, in practice, there were already some US listed firms went back to mainland or Hong Kong markets, but most of them went back to the Hong Kong markets because of the BVI arrangements. Again, I should mention the impact of regulation again, because why these Chinese firms use complex contractual arrangements with BVI arrangements is to circumvent the Chinese regulations issued, which named the number 10 document issued in 2006. According to that document, you need like 26 applications and 8 approvals to be listed overseas. So most Chinese firms just use these BVI arrangements to circumvent this regulation. So again, the regulation creates unpredictable circumvention effects. So these Chinese firms, if they want to go back and to be listed in the mainland China, they must disseminate their BVI contractual arrangements. So that's a very complex process. So most of them choose the Hong Kong market. But I think it's impossible that most Chinese firms will delist from the US market because of this act, because I think it's like the US gave China 3 years, like a grace period, give you a deadline. How could you solve this problem with me, like within 3 years? And I'm quite optimistic that this problem will finally be solved, because this is not a dispute that cannot be solved, because it's for the US side, it's also for its interest to attract more foreign firms to listing in the US market. Remember that in 2002, in the SOX Act, after it's issued, then some foreign companies choose to delist from US because SOX improved the information disclosure requirements. So the US just issued some exemptions for these foreign private listed companies, like they do not need to submit like quarterly reports or whatever to attract more foreign firms to be listed in the United States. So as long as the US market want to keep us as the most vibrant and most the deepest securities market in the world, I think it will not kick out our Chinese firms. So finally, I'm optimistic for the future.
Okay, thank you, Xiao-chuan. Then the next question is for Professor Ling. The question, of course, thanks, Professor Ling, for your clear and great presentation. The question is there a unified law regulating social credit system at the national level? What are the prospects of further integration at the national level? Please.
Okay, thank you. So actually, there is the national level. There are guidelines, governing social credit system, but there is no a unified law on social credit system. But it's underway. So there is a draft since 2019. So it's been in discussion in the National People's Congress about having a unified national level social credit law, but it's still under discussion and might be passed, maybe this year or next. So currently, the law has been passed in different provinces. It's all at different at the local level, and I guess the government wants to see how it has been implemented locally and see if there's any problems, and they can rectify it in the national law. But it's coming. And actually, in 2021, just this year in July, the government published, two documents actually in relation to the public credit assessment. So one is on the scope of data collection. Okay, so I think there are two main issues. One is on the scope of data collection, like what can you collect, right? Like what type of data that the government can collect for the purpose of building a social credit system. Now, the other is the type of punishment measures that can be taken by the local government, based on the results of the assessment. So there are two national level. Actually, it's also a draft that's in discussion. So it published in 2021 July. That's on the public credit information catalog. So the national level document, the Chinese government, they publish a detailed catalog on what type of information that local government can collect, and that restricts the local government's ability to collect information. So I think it specifically says that you cannot collect information on, people donating blood, or there are some restrictions on the type of data that can be collected. And the other is a draft document on the punishment measures. So they specifically says, if the government wants to restrict a person or enterprise's rights and liabilities, rights and obligations, then you need to follow the law. Okay, so, and there are some other things that you can do is if you are just implementing management measures, like for example, granting, like giving out awards, right, or rewards for those who done well, the companies who done well in the assessment. That is okay. That's called the management measures. So there are different restrictions, in relation to the scope of data collection and also the type of punishment measures that can be done. And I think there's, of course, there's a prospect of further integration at the national level that is coming, but now it's kind of fragmented, in like different provinces, different cities that have different standards. But I think it's going towards a integration maybe in the next few years. Thank you.
Okay. Thank you, Lauren. The next question is for Xiao-chuan from Sean. That is, how effective are monetary punishments in the form of fines when companies that violate accounting law and unfair competition law made more money from breaking the laws compared to the fines they get? And can we say that this monetary route as a form of punishment serves as a deterrent, or we need to consider alternative form of punishment? Xiaochuan, please.
Yeah, could you also copy and paste that question to the meeting chat, please?
Yes, no problem. I can do this. Meeting chat. How to do this? Let me try. Yes, meeting chat. Can you see that?
No, but I can still remember a little bit about the question that is about the fines, right?
Yeah, it's a little bit long. Yes.
But still trying to post it in the meeting chat, please. And I'm answering now. I hope later I will see the question appear because it's a long question. It will be better if I can see that in the meeting chat. And so I think if you ask for the fines, the effective of the fines, first, I think it's like under the accounting law or the anti-unfair competition law is just an excuse. Because the regulators, what they really want to punish is the false statements on the securities law, but because they cannot do that, they choose to use other excuses, and China for a long period of time have been criticized for like the fines is disproportional for its for the false statements, for the damages made caused by the misstatements. Like the fines, even under securities law, it will be a very small portion, a very small number compared to the gains that from their false statements. And on the other hand, you know that class actions in China are very rare. So most like the wrongdoers, they like very little fines from the security regulators, and like very rarely they might be punished through the court system, through the class actions. And in recent years, like the Chinese regulators do propose a way that like the underwriters pay first. For example, Weng case, the underwriters will just pay all the investors for their losses, and then the underwriter will then seek for the issuers for their compensation. But it's a new practice, and it's like a case by case one. It's not a routine practice. So the deterrence effect from the Chinese securities law is very weak. And could you repeat the second part of the question?
Okay, the second part of the question is, can we say that this route, a form of punishment, serves as a deterrence, or we need to consider alternative forms of punishment?
Well, in the expectations of the lawmakers, it should be a punishment, but in practice, it is not. As I mentioned, the number is very small, and the case is like in U.S. And as long as you do the false statements, you will be sued on the class actions. But in China, it's like 10 out of 100 they might be sued. So the rate is very low. So the deterrence effect.
Okay, it seems Xiao-chuan is freezing up, but I think he's almost finished answering that question. Hopefully, I think we don't have too much more time for more questions. Everyone, time flies. I believe you all enjoyed the session very much, and time's too short for us to discuss all the questions from participants. As Professor Wei Zhang mentioned, higher legal liabilities are supposed to incentivize professionals to play a more effective role as gatekeepers in securities issuance. However, such a benevolent outcome will arise only if liabilities are proportional to culpability. Otherwise, intensify the blame over professionals will just be scapegoating. It may even further compromise the protection of public investors. Lauren thinks the categories used to determine scores in Zhejiang are very broad, potentially giving significant discretion to officials operating the corporate social credit system. She examines the scores of all publicly listed companies located in Zhejiang, focusing on the ownership structure and other characteristics of companies that deviate positively or negatively from the baseline score received by the vast majority of companies, and scoring decisions accounting for their high or low scores. Xiaochuan believes cross-listing and the regulatory cooperation will benefit both China and the US for their long-term interests. Her presentation demonstrated how a US-China relationship changed cross-listing rules and what impacts these rules will impose on the capital market and a market player. All topics being discussed are vital for us to understand the implication of corporate law under the turbulent times. They also will evoke more discussion or echoes in academia, I think. I believe corporate law, although it is shaping the world while being shaping, will bring the world more prosperous than conflicts. Last but not the least, I think I need to thank CIBEL for the excellent chance for us to discuss the corporate law over here. Also, I owe all speakers a big thanks for the great presentations. Additionally, without all our excellent CIBEL staffs, Fion, Weng, and Sophia, this webinar will be much harder for me to organize. I'm sincerely appreciative of what they have done for the webinar. More importantly, thanks to you all for participating in today's session. Stay safe and healthy. See you guys.